evening and welcome. Thank you for tuning in. I'm Samilana Sumalinog, and this is Legal Basics for Teens. Today's top story, what makes a contract? We've all encountered contracts in our lives, whether clicking on the terms and conditions when creating our TikTok accounts, or watching The Little Mermaid when Ariel signed away her voice to Ursula the Sea Witch in exchange for legs. But what exactly counts as a contract? Is it any agreement you make? And what makes a contract totally binding? In legal study, contracts are abbreviated as the letter K. A contract is an agreement between two or more parties to carry out a duty. You may think of it as a legal document that binds people to do what they promise. Sometimes that promise is paying someone, sometimes that promise is performing a service, and sometimes that promise is purchasing a good. If the agreement is oral, spoken agreement, that is, no written down, it is still enforceable. But first, you have to prove that it existed, which can sometimes be hard to do. Enforceable means that the contract is legally binding, aka a court can order the parties to follow the terms of the contract. Enforcement also requires that the parties had the capacity to enter into the agreement. Additionally, the parties must enter a contract voluntarily, meaning there were no threats or coercion to convince someone to enter a contract which they do not want to be bound to. Both parties must recognize and intend that the agreement is binding. For a contract to be considered valid or enforceable, it must meet three elements. There must be an offer, there must be an acceptance, and there must be a consideration. But what do these things mean? Joining me now live in the studio to explain these elements further is Rutgers 2L Dina Mansour. Dina, how are you doing today?
I'm doing great.
So why don't you tell us a little bit more about contracts?
Thanks, Sam. When we look at whether a contract is a valid contract that the parties can be forced to follow through on, we need to make sure that the contract has all three elements: offer, acceptance, and consideration.
So these elements you're describing are like a checklist.
Kind of, yeah. We can look at a contract and follow down the line of elements. If a contract is missing one of these outside of the exceptions, then it is not considered enforceable. A court can't make you follow through on it. So to start out, what is an offer? The offer is just what it sounds like: a specific proposal by one person to another to make a deal, such as lease you a car, sell you a guitar, paint your house, or simply pay you. The person making the offer is called the offerer, and the person to whom the offer is being made is called the offeree. Here's an example. Say two siblings agree to host a 50th birthday party for their mom. The brother says to the sister, "Let's share the cost of the party." The sister agrees. 1 week later, the brother gets the bill for $1,000 and tells the sister that she owes him $500. The sister refuses, saying she can only give him $100. Since the brother never specified that by sharing the cost, he meant an even 50-50 split. A judge could not enforce the agreement. The offer was not definite and certain. Second, the offer must be accepted. Acceptance is the act of agreeing to an offer and becoming bound to the terms of the contract. Acceptance means that you agree to what is offered without any changes. You can accept an offer in a variety of ways: in person, verbally, through a written agreement, by fax, email, or by action. For example, if I put up a sign that says, "I will pay you $200, whoever paints my house," and you paint my house, that's considered acceptance by action. Silence is never considered acceptance, unless the parties that have agreed that it would count as acceptance, or if the parties had silence count as acceptance in their past agreements with each other. Once there is an acceptance, the contract is formed.
So say you offer to sell me your car for $5,000. If I say, make it $4,000 and you've got a deal, does that count as acceptance? Would we have a contract?
No. If you agree to an offer, but only if a change is made first, it is called a counteroffer. And even though I made the first offer, now I have to accept your counteroffer before there's a valid acceptance. This is called the mirror image rule. The mirror image rule means that the terms stated in your acceptance must exactly mirror or match the terms of my offer. Finally, there needs to be consideration. Consideration is anything of value promised to one party in a contract in exchange for something else of value promised by the other party. Courts don't usually look at consideration to decide if it was adequate or not, because a thing of value can be different from situation to situation. Paying $5,000 in exchange for my car, the consideration is the $5,000. Consideration can also be an action. If you agree to fix my car, if I bake you a cake, my baking the cake is the consideration. However, if you already had a duty to do something, that won't be considered consideration. An example of that is, say a father offers his 13-year-old son that if he doesn't smoke cigarettes or drink alcohol until his 18th birthday, he'll take him on vacation to Vegas. When the son turned 18, his father refused to take him on vacation. So the son sues his father. But the court would side with the father because the son, by law, had a duty not to smoke or drink and under the age of 18. So because the consideration was a pre-existing duty, there was no contract.
Let's go back for a minute. You said that courts don't usually decide if consideration is adequate. So if, for example, you and I agree to trade my Toyota for your BMW, even though the BMW is worth a lot more money, the court would still say that is valid consideration?
Yes, the judge won't rule on whether the consideration made sense, as long as you and I both had the capacity when we made the agreement and agreed on the consideration. Having capacity means having the legal ability to enter into a contract. Thank you for having me.
We now go live to our reporter on the scene in England, 1892. Reporter Jamie Portillo, a Rutgers Law School 3L, with the story.
Thanks, Sam. To combat a flu pandemic that started in 1889, the carbolic smoke ball company made a product called the smoke ball. This product was a rubber ball with a tube attached that was inserted into the user's nose. When the rubber ball was squeezed, it would release carbolic acid vapors up the nose. These vapors would cause someone's nose to run, and theoretically, that running would flush out any germs and prevent a person from getting sick with the flu. In fact, the company was so sure that the carbolic smoke ball would prevent the flu that they put an advertisement in the paper Mall Gazette on November 13th, 1891, claiming that it would pay $100 to anyone who got sick with influenza after using its product according to the instructions provided with it. The language read exactly, quote, $100 reward will be paid by the carbolic smoke ball company to any person who contracts the increasing epidemic influenza cold or any disease caused by taking cold after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. $1,000 is deposited with the Alliance Bank, Regent Street, showing our sincerity in the matter. During the last epidemic of influenza, many thousand carbolic smoke balls were sold as preventatives against the disease, and in no ascertained case was the disease contracted by those using the carbolic smoke ball.
Wow, that sounds like they were pretty serious about how good their product was. I'm guessing with that kind of confidence, none of their customers caught influenza, right?
Unfortunately, not right. Miss Louisa Elizabeth Carlyle saw the advertisement, bought one of the balls, and used it 3 times a day for 2 months, but sadly, she caught the flu in January of 1892. Her husband, a lawyer, then sent the carbolic smoke ball company multiple letters requesting that they send her the reward like they advertised. At first, the company ignored her, but when they finally did reply, they implied that she used the carbolic smoke ball wrong and said, quote, to protect themselves against all fraudulent claims, Miss Carlyle will have to come to the office every day and show the secretary how she was using the ball. So Miss Carlyle took it to court, arguing that the advertisement in the newspaper and her reliance on its promise created a contract between her and the company owed her £100. But the company argued that the advertisement was too vague to enforce and was not meant to be in the serious contract. They said it was, quote, mere puff.
We just learned that the elements of a valid contract are offer, acceptance, and consideration, and the parties must intend for the contract to be valid. Were all of those present here?
Well, the court concluded yes. The judges said that the company's argument that they didn't mean for the advertisement to be taken seriously was a bad one, because the advertisement itself said the company deposited £100 reward money with the bank to show their sincerity. The court also said that even though the offer wasn't specifically made to Ms. Carlyle directly, the advertisement was an offer made specifically to anyone who performed the specific conditions of using the ball 3 times a day for 2 weeks. Furthermore, the court said that Ms. Carlyle's actions of using the smoke ball with the intent of either not getting sick or getting a £100 reward counted as acceptance. Finally, the court found that there was consideration because the company intended for their sales to go up as a result of the advertisement. The court also found that the contract was not too vague to enforce because they determined that an ordinary person would interpret the words of the advertisement the same way that Ms. Carleo did. So because there was a specific order made in the newspaper advertisement, and Ms. Carleo accepted it by following the terms, and there was consideration, the court found that there was a valid contract and the company had to pay her the £100 reward they promised. Reporting live, this has been Jimmy Portillo with Legal Basics for Teens.
Hi, I'm Alyssa Frank reporting breaking news on the issue of determining whether an offer is serious. We're receiving reports from the United States District Court for the Southern District of New York, where they just ruled in the case of Leonard versus PepsiCo. Plaintiff John Leonard had sued Pepsi after a commercial on TV seemed to imply that for 7 million Pepsi points, the company would send you a military-grade AV-8 Harrier II jump jet. Pepsi points, similar to Chuck E. Cheese tickets, could be collected and eventually traded in for prizes. A person could find these Pepsi points on specially marked Pepsi products or could purchase them for 10 cents a point. This suit all began over a Pepsi commercial. In the commercial, a teenager flies himself to school in one of these military jets, which is labeled as costing 7 million Pepsi points. Pepsi claims that this commercial was intended to be humorous and that no reasonable person would take the commercial as a serious offer. Leonard only had 15 points, but he mailed a check to Pepsi for over $700,000 to purchase the remaining points plus the shipping fee, expecting that he would be sent the Harrier jet as advertised in the commercial. What's that? Okay, we've just received word that the verdict is in and that the judge has sided with Pepsi, that the commercial was a joke, quote, evidently done in jest, and that the notion of traveling to school in a Harrier jet is an exaggerated adolescent fantasy. To support that conclusion, Judge Wood pointed out evidence in the commercial itself that indicated it was never intended to be taken as a serious offer. This evidence included that the teenage boy was piloting the jet himself, despite the fact that he, quote, could barely be trusted with the keys to his parents' car, much less the prize aircraft of the US Marine Corps. Judge Wood also wrote that, quote, no school could provide landing space for a student's fighter jet or condone the disruption that the jet's use would cause. For these reasons, among others, the judge rules that Pepsi did not seriously offer point bearers a Harrier jet and that there was no contract. This has been Alyssa Frank, Legal Basics for Teens.
And now our meteorologist has more.
Hey viewers, this is Sawyer Like of Rutgers Law School 3L with the T on capacity. It's important to understand what it means to have capacity to enter into a contract. Capacity means that someone is recognized by law as having the ability to enter a contract. If someone who doesn't have capacity enters a contract, then that contract is voidable by them, as the person who lacked capacity to enter the agreement in the first place. Voidable means that the person without capacity can choose to end the contract or permit to go ahead as agreed on. There are 3 types of people who lack capacity to enter a contract. Minors under the age of 18 lack capacity. A minor can void a contract only while still under the age of majority, and only if the contract is not for necessities like food, clothing, or shelter. Next is people who are mentally incapacitated, such as someone having an episode of mental illness. In most states, to determine if a person is mentally incapacitated, we apply the cognitive test, which asks whether the party understood the meaning and the effect of the words that make up the agreement. In other states, a contract can be voided if one party is unable to act in a reasonable manner and the other party has reason to know of their conditions. Finally, a person who is drunk or under the influence of drugs does not have capacity. This one is trickier because courts generally rule that someone who is voluntarily intoxicated should have to take responsibility for their actions they make. However, if a person is so drunk or high that they can't understand the consequences of the agreement and the sober party takes advantage of the person's condition, then the contract may be voidable by the inebriated party. And that, ladies and gentlemen, is the T on capacity. And back to you, Sam.
So to recap, a contract is a bargained for agreement between two or more parties. For the agreement to be enforceable, it must have a specific offer, a clear acceptance, and a new consideration. The parties must also have the capacity to enter into the agreement when they make it, otherwise it is voidable. Still to come ahead, your regularly scheduled law class. What will you learn today? Be sure to show respect to your teachers and fellow students, and remember, you never have to talk to the police without a lawyer present. Thank you for joining us and have a good day.